Today we're gonna be doing our estate planning seminar, which is basically working on will awareness and trust and what a person needs to be ready for that time when they pass and their relatives need to settle their estate. I'm your presenter. I'm Roxanne Indermule. I'm an estate planning specialist with His Faithful Stewards. And as you can see there, for our estate planning purposes, we work with an attorney created software called Forecast Estate Planning. I'm going to start by telling you John and Linda's story. They were parents of a colleague of mine. They had assumed that when one of them passed away, the other one would just inherit their entire estate. And what happened was John passed away, but the state laws were such that they'd actually divided John's portion of that amongst all of his living family there. So between Linda and the four daughters. Well, three of the four daughters said, well, that's not a problem. This is all mom's, and mom will have it all until she dies. But then the third daughter decided she was going to go ahead and take her share and go. So it made the whole situation kind of messy. And it was something that planning ahead would have helped a great deal in avoiding. And again, I'm Roxanne Indermule. I am the estates planning specialist. I do estate planning, wealth strategies, and I'm also a retirement specialist. The estate planning is generally a team approach using a lawyer, a CPA, and a retirement specialist. This presentation is intended for educational purposes only. I am not a lawyer or a CPA, and I'm not giving any legal or tax advice. I recommend that you consult with your own legal or tax professional. And to save time, well, there won't be any questions today anyway until at the end of the recording. So, topics for today, we're going to be talking about sickness, death, and the power of taking control. We're going to answer some questions like what is included in your estate plan, the role of the power of attorney, the will versus a living trust, probate made simple, important terms and documents, what if you have an existing trust, restatement of your trust, and we're going to look at a new and affordable solution to a complex problem. So, what happens when tragedy strikes? I mean, we help educate families about estate planning options before the unexpected strikes or they're incapacitated or worse. The first thing is let's talk about a durable power of attorney. So a durable power of attorney appoints someone to make financial and healthcare decisions on your behalf should you become incapacitated and you can't make those decisions on your own. Examples of that might be if you were to develop Alzheimer's, dementia, or perhaps you were in an accident and ended up on life support or had a bad heart attack. So the question is, do you want to be able to pick who's going to be making those decisions for you? Most common type of durable power of attorney is a springing power of attorney, and it becomes valid with your doctor's signature. That's intended to give you some peace of mind for you and your loved ones that your decisions have been made ahead of time, and it avoids any last minute burdens on your loved ones trying to guess what you might want. There's only two options for your estate. There's either the government plan or there's your plan. The government plan is probate, which is the legal transfer of estate assets. It happens with or without a will. And when you're dealing with a will or in probate, assets are frozen and creditors are given notice to be able to make claims against the estate if they have any claims. It requires hiring an attorney and it puts the courts in charge. Heirs go through the probate process. It is expensive and it's stressful, and they have to come up with the costs all up front before the estate settles. If somebody has property in more than one state, then they have to go through probate in each state in which they have taxes. It makes a long wait for the distribution of assets, and it's a very public process. Everything that you have is posted where it can be viewed by anybody. Now, your plan would be a revocable living trust. With a revocable living trust assets are not frozen. Heirs avoid probate. There's a trustee that's in charge instead of the courts. You can decide whether you want the assets to be delivered to your heirs in a lump sum or in sprinkle payments over time. There's special needs option in case there's somebody with special needs that needs to be protected as well. There's also spendthrift options that protect people that might need to be protected from themselves. And it's much quicker to distribute assets. On top of the fact that it's also a private process that none other than those involved need to know anything about. So what kinds of things are included in your estate? Well, it'll include everything that you own, personal residences or any kind of other real estate you might own, vehicles, cars, trucks, motorcycles, boats, RVs, planes, bank accounts, checking and savings accounts, CDs, safety deposit box, your brokerage accounts, retirement accounts, investments, life insurances, annuities, gold, silver, mineral and oil rights. Perhaps you have some family heirlooms or jewelry, art, guns, stamps, or coin collections, furniture, or other personal property, especially things that have any kind of sentimental personal value to them. There's also any kind of family or individual businesses. So when does something go to probate and when does it not go to probate? Well, if somebody dies what's called intestate, that means they've died with no will or no trust, and their heirs are going to go through probate, and the courts are going to decide where everything goes. And it's going to be usually based on state law. A will will also go to probate. Your wishes are recorded, and as they go through probate, they do their best to honor those wishes. Now, a revocable living trust is your wishes are recorded, but your heirs avoid probate, and they don't have to go through the government process. So let's talk about wills and probate and when that's required. So a will is really fairly simple to set up. You can hire a lawyer or you can actually do it yourself. No one will for each person. You need one will for each person. So that means if you're married, you each need a will. So there's 2 wills involved if you're married. It's all about your wishes, but it still does go through probate. After probate, the assets are transferred as soon as possible and they're transferred in full. It is a public document. Kinds of things that you will find in probate fees. So when somebody goes through probate, these are things that have to be paid along the way. There's attorney's fees, there are probate court fees. A lot of times things have to be appraised, so appraisal fees. Estate taxes, income taxes all have to be paid off. Management fees, money owed to creditors. Any kind of lawsuits that are pending would have to be settled. Catastrophic medical care. So if someone's had catastrophic medical care near the end of their life, all of that's going to have to get paid off as well before any funds are going to be released. The length of time before settlement can be extensive, and some estates actually never settle. AARP sets out that the average cost for most estates to go through probate is at least 10%. So on $1 million estate, you're talking about $100,000 in fees. And that can be at the low end. That's providing nobody challenges that will. Now, in the trust process, who helps with your legal and financial planning? And here's some questions to ask is my attorney planning for a probate or is he planning for a transition of my assets? Has my financial advisor had an estate planning conversation with me? And if not, why not? Also, we could have a holistic approach and conversations that weave together assets, retirement, and estate planning that are tailored to your goals and your concerns. And that's kind of what we do at His Faithful Stewards, is that whole holistic approach where we're going to pull all of those things together. Now, the way a revocable living trust works is it avoids probate, because you take all of those assets, your cars, your house, your bank accounts, and those things, and you bequeath them into a revocable living trust, which creates a contract. It's revocable up until the time that you pass away. Once you pass away, it becomes irrevocable, and the trustee that you have elected takes over and does the disbursement. So your heirs then are able to get a hold of the the assets that you have left behind and are able to go ahead and move forward with that without the court's involvement. Because of the fact the trust actually totally bypasses probate and the courts. A revocable living trust is not intended to be a tax-saving strategy, and it doesn't protect assets from creditors. It's basically a estate planning tool to avoid probate. Now let's talk about a revocable versus an irrevocable trust. So a revocable living trust is designed to avoid probate. You're in control and of all of your assets while you're alive. You can put them into the trust, you can take them out of the trust because it's revocable. Assets transfer from you to you as trustee. But as I said, you can change your mind as long as you're alive on that. It does become irrevocable upon death. Now, an irrevocable trust is designed to protect assets. You're legally removed from all rights on an irrevocable trust and to the ownership of the assets. The ownership rights now belong to the trust, but you can retain control of those assets. But ownership can no longer change with an irrevocable living trust. So some important terms and important documents to know about when you start talking about an estate plan is first is a grantor. A grantor creates a trust. That's usually you setting up your own trust. An executor manages the probate and distribution of a process if you have a will. A trustee manages the trust, and that's usually going to be you as long as you're alive. A successor trustee is the person who manages the trust upon the death of a trustee or the incapacitation. A beneficiary is someone who receives the assets from the trust. The durable power of attorney for healthcare and finance, that's a document that's in place in case you are incapacitated that allows someone to make those healthcare and financial decisions for you when you are not able to do so. There's an advanced directive document for the power of attorney. And what that does is it's a document in which you lay out what your wishes are in the event that you're incapacitated, like how long do you want to be on feeding tubes or artificially kept alive? Questions of that nature are things that get answered in advanced directive documents. There's also a certificate of trust that you use as proof that the trust exists. And then there's the term funding your trust is actually the process of moving all of your assets into the trust. There's also, if anybody has someone with special needs in their family, there's also a need to have a special needs trust in place. And that needs to be part of the estate planning package. It's so that the beneficiary who's on government assistance won't lose it when he or she inherits assets. The process is a trustee is appointed to disperse assets based on certain needs, and it gives peace of mind to identify a guardian for when you die. There's also spendthrift provisions optional within these trusts, which protect assets from a beneficiary who may not make wise decisions. That could be due to having addictions, mental illness, or maybe they're just someone who's really easily influenced by others, and so you would prefer they not be in the decision-making capacity. And that the whole trust not be able to be hurt by one party. Now, the process, a trustee is appointed to distribute the assets based on your wishes. So again, it gives you peace of mind to know that assets will be used appropriately and on an appropriate time schedule for the beneficiary. So there's a couple of different ways that you could have your beneficiaries articulated in these policies. There's per capita. And that's per capita, it means the total number of individuals. In a per capita inheritance, should both parents and one beneficiary child die and they have an IRA, that IRA would be divided equally among the remaining beneficiary children. The other option is per stirpus, and that's generational. In a per stirpus inheritance, should both parents and one beneficiary die, the percentage of the remaining IRA that would have gone to the deceased child now goes to his or her beneficiaries. So if you look at this chart, you can see how Allison, on a per stirpus, Allison leaves her estate to her sons, Ben and Frank. if Ben were to die in a per stirpus inheritance, then Ben's two children, Candace and Danny, would split the half that would have gone to Ben, so they each get a quarter, and then Frank gets his half. Now, if it was the per capita statements, then Allison is here, and here's the two sons, Ben and Frank, and then if Ben passes away and predeceases, it means the entire estate would then go to Frank. It wouldn't pass down to the other heirs. And that's what the difference is between per stirpa and per capita, and how the estate is passed on. So let's talk about funding your trust. Ironically, 70% of trusts that are set up never get funded. You have to think of your trust like a big empty box. And you create the trust, you create the box. But in order to make for that to do you any good, you have to actually fund it or put those things into the box. So funding is that process of moving assets into your revocable living trust, or this box that you created. If an asset is not in the trust, then that asset goes to probate. Assets that you might not put into a living trust, but rather the trust could be the beneficiary of them, would be things like your qualified retirement accounts. Those are tied forever to your Social Security numbers, your 401ks, 403bs, IRAs, any kind of qualified annuities, health savings accounts, medical savings accounts, uniform transfers to minors or uniform gifts to minors. The beneficiary could be the trust, and it could distribute from there according to your wishes. Possibly life insurance, depending on what kind. You also need to consider tax issues. So what about income tax? Well, revocable living trust and taxes. Well, during a creditor's lifetime, the taxpayer's identification number on the trust will use the creator's Social Security number. So everything stays tied to you as long as you're alive. And all items of income, deduction, and credit will be reported on the creator's personal income tax, and they don't need a separate return to be filed for the trust itself because it's all seen as an alter ego of you. So upon the death of a creator or grantor, then the trust will file its own tax return and get its own EIN. The taxation on assets that are received as a beneficiary. Generally, beneficiaries do not pay income tax on money or property that they inherit. There's a setup in the cost basis rule that applies for capital gains on inherited accounts. So looking at the date of death, and then they're responsible for any growth in the account after the date that the person has passed away. Taxes due on income that comes from the trust. So money inherited from a 401k, 403b, or a traditional IRA, since those were tax deferred accounts, when that money is inherited, it is taxed and it's taxable. So, but there's no tax due from a Roth IRA if it's at least 5 years beyond the 5-year rule, or and there's no tax on the death benefit from life insurances. So why is it that most people don't do proper estate planning? Well, often it's because they don't want to hire an attorney. They think it's too expensive. They think it's a time-consuming process. They just really are unsure what to do. They're avoiding the conversation because they don't want to have a conversation about what happens when they die. Belief that trusts are only for the very rich, and not fully understanding the burden on the loved ones that will be left behind when you pass away. So procrastination is to delay or postpone action, or to put off doing something you know you need to do. So, and when you do that, it passes that burden along to your heirs. And so procrastination is simply not okay. So right now, I'm going to have you take a little bit of stock of yourself. And if you want to, I should have had you grab a pencil and paper to start with, but I'll give you just a second to grab a pencil and paper because you're going to write down some numbers and then you'll add them up afterwards. And this is purely for your own benefit. This is a question of, do you need a will or do you need a trust? Now, I'll wait just a second and let you grab a pen or pencil. So in the first question is going to be related to your home. If you rent your home, give yourself a 0 for points. If you own a property, a home that has less than 50,000 in equity, give yourself 2 points. If you own one or more properties and between them there's 50,000 in equity or more, then give yourself 5 points. So you rent 0. If you have less than 50,000 equity, 2 points. If you have one or more properties with 50,000 or more equity, then give yourself 5 points. Now let's talk about children. If you have no children, give yourself 0 points. If you have minor children, give yourself 5 points for each minor child. If you have healthy adult children, give yourself 3 points for each healthy adult children that you have. And if you have any disabled children, give them 5 points each. Now we'll talk about valuables. If you added up everything you own, including clothes, electronics, cars, boats, jewelry, collectibles, and everything except for real estate, roughly how much do you think it would be worth? If you think it would be, oh, there's a typo here. So if you think it would be less than $25,000, give yourself 2 points. Again, ignore what it says on the slide there. So if it's less than $25,000 of what you would have in valuables, then give yourself 2 points. If what you have would be worth 25,000 to 50,000, give yourself 4 points. If what you have when you put all those things together would be more than 50,000, give yourself 5 points. Then also we're going to talk multi-state. Do you own property in more than one state? If the answer is no, give yourself a 0. If the answer is yes, give yourself 5 points for each state. Let's talk about privacy. If you care if a list of all your belongings become public and detailed and made available online after you pass. If no, you don't care, give yourself 0 points. If you would like things to stay private after you pass, then yes, you would like it to remain private, give yourself 4 points. Also, incapacitation. If you are incapacitated, do you want to decide who manages your personal affairs, your health care, and your assets? And if it doesn't matter to you that either the court appoints someone or your spouse does that, then give yourself a 0. Or yes, if you want to be able to select that person yourself, give yourself 4 points. So how did you score? If you scored 0, you're okay without an estate plan. You want to be sure that all of your bank accounts have a notation for payable upon death and who you want to have paid to those. But that's about all you'd need to do and you'd be good to go. If you scored 1 to 5, you need at least a last will and testament, and you should consider a living will with advance directives as well. If you scored 5 or more, then you do need a comprehensive estate plan, and your plan should include a revocable living trust, a will that's a pour-over will for things that didn't get put in the trust, a power of attorney, and a living will with advance directives. So what is in a complete estate planning package? Well, a will package will have a last will and testament, which says what you want to happen to all of your possessions. It has a financial power of attorney and a healthcare power of attorney. The financial power of attorney is a person who can make financial decisions for you if you become incapacitated. Healthcare power of attorney makes the decisions on your healthcare in the event that you're incapacitated. And the living will with the advance directives is what spells out what you would like to happen if you became incapacitated. So that's what a will package would look like. A revocable living trust has a little bit more in it. It has the financial power of attorney and the healthcare power of attorney with the living will and advance directives, just like the will package. Now, it also has a pour-over will to catch anything that was missed and being put into the trust. It also has organ donor provisions in it, special needs options if there's a special needs person involved, spendthrift clauses to protect people from themselves, and the certificate of trust. So it's your choice for your estate. The first choice is you can just don't do one. Just leave it set and let your heirs take care of it. you do nothing and you make no plan. The second option you have is to hire it. You can hire an attorney to set up your will or your trust, or you can do a done with you program where you take control of the process through technology. Done with you, do it yourself models is not something new. Most of you are probably familiar with TurboTax, which is exactly the same kind of thing as what we're looking at here, or LegalZoom, or any other kind of estate planning documents where you can go online, put in some information, and it generates the document for you. So we work with an attorney-owned firm called Forecast Estate Planning, and it's one of America's best comprehensive online estate plans that saves a whole lot of money, and you're actually able to go on and get attorney-created documents. They use user-friendly software with video tutorials and FAQs, examples of different things to help you understand. Our documents are written by estate planning attorneys. The documents are approved in all 50 states, and getting a will or a trust is a 3-step process. Step number 1 is our team educates you on wills and trusts, and then you purchase the plan that best fits your situation. You identify who, what, when, and how you want things distributed from your assets after you pass away. We input that data into the system with you. Once the attorney drafted documents are completed, once all those things are done, and once you've approved those, we print those trust documents and then we mail them to you. Then we move to step 2. Step 2 is that you'll sign those documents in front of a notary. You'll need 2 witnesses. Usually a local bank is where most people get those done. Then you can scan those documents back into your digital vault so that they're safe and secure. So if you were ever to have a fire in your house or something should happen, you always have an electronic copy of the documents available. And then we go to step 3. And step 3 for the revocable living trust is it's funding or titling the trust. So the funding kit is something that's included, and our team is available to assist with this process as well. What you're looking at right there is just a snapshot of some of the funding kit that is available that helps you think through and know what all you need to put into that trust. So do you need a revocable living trust? The revocable living trusts are usually a fit for about 95% of our clients. They're fully customizable. They're attorney-drafted documents that are legal in all 50 states. They're affordable. They're convenient. You have access to our team to assist you with the technology or any questions on educational questions that you might have. And then any kind of updates and changes happen at no cost, little to no cost to you. Like maybe the cost of reprinting documents, but there's no additional fees or anything for when life changes and you need that to be reflected in your documents. So how do we help? What do we actually do? We gather the data needed for your plan. We do a financial review of assets and beneficiaries. We print, tab, and bind the documents that the attorneys draft, and then we assist you with the funding of the trust. Then we do annual reviews so that if there's changes needed, you'll know how to make those, because life changes. Life doesn't always stay the way you expect it to. So how much does estate planning cost? The national average is about $1,200 to have an attorney draft a will package, or $6,000 to $8,000 to create your trust. And that typically does not include funding of the trust or any updates for that. The package that we're talking about here, the revocable living trust, has income only options, which has an A and B trust option. Those are for usually estates in excess of $5 million. There are spendthrift provisions in the IRA look-through. Includes the financial power of attorney. It includes the healthcare power of attorney, the advance directives, living will, the pour-over will, the special needs options, the spendthrift options, the certificate of trust, online funding kit, unlimited funding letters, The first year for the document vault, the $29.95 is included in the initial cost. There are unlimited changes, unlimited updates, and unlimited restatements for that trust. And the cost for the complete revocable living trust system through Forecast is $29.95. There are some bonus gifts that also come with that. There's a free consultation with our team. That's our gift for appointments booked in the next 10 days. That's a $750 value. We also provide assistance with the funding kit, which is no additional cost to you. It's a $1,500 value. We do a review of all of your financial assets and beneficiaries with you, which is an additional $1,500 value that costs you nothing. And then we serve your trustees and your power of attorneys at no cost, which saves them about $400 an hour as well. So the takeaway from all this is the government's plan is probate, or your plan would be a revocable living trust. Which plan would you want? Here are 3 questions that you might ask an attorney if you were going to interview an attorney to do these for you. First, ask them if the trust that they create, is it done on a software package like ProDocs? So is it basically the same kind of software package that we're showing you here that comes through Forecast? I mean, then we ask the attorney, do you help me fund the trust? And if so, does it cost extra? And usually how much? Then number 3, when I need changes or updates, what are you going to charge me to do those updates? And give me some examples, please. So some closing thoughts for you to consider. Who do you want to inherit your assets? What do you want each beneficiary to receive? And how do you want them to receive them? Do you want them to receive them in a lump sum or a partial over time? Do you want it immediately? How do you want that distributed? And then what happens to your beneficiaries if you don't make a plan? It's your estate. Take control of it. Next steps would be to schedule a 45-minute call with me, with Roxanne, and that's a gift, our $750 value gift for appointments booked in the next 10 days. And you can get peace of mind knowing that your documents are in good order. So here's our contact information. Let's chat. Give me a call, give me an email. There's a website if you'd like to go learn more about us. But thanks for giving me your time today. I'll leave this up for just a minute here so you can copy down our contact information, and I wish you all the very best.